Thanks, Jason. Hi, everybody. Thanks for coming out this evening and taking time out of your busy schedules to come and talk and listen to a little bit about Maryland HOA and condo law. As Jason mentioned, I'm an attorney. I practice law and represent associations throughout Maryland, DC, and Virginia. We're based here in Maryland in Anne Arundel County and represent associations throughout the state. I am here to give general advice and commentary. This is not specific legal advice for any association, but I will try to point to sources, including especially the Maryland Condo Act and the Maryland HOA Act, where relevant to kind of help give you some guidance. And at the end, I will talk a little bit about some of the recent legislation that went into effect to give you a little bit of an update of what that might mean for your association. As Jason said, I'm going to try to hit a lot of high points. So if you have a question, either hang on to it or put it into the chat. And that way, potentially, I will get to it as we go through. And if not, there will be an opportunity at the end to address a few of those and answer any questions that might come up if possible. And with that, here we go. So when we talk about an association in Maryland, there are a lot of conflicting and or intersecting laws that govern what we do as an association. And one of the things that I say to a lot of clients and right at the outset is you are a business, right? You are governed by the law. You do have certain rights, obligations, restrictions on what you can do and not do in terms of the board, in terms of board function, and in terms of what is prescribed by statute. And so one of the best things you can do is know how those, what those are and how those intersect. So the priority of laws, for instance, if there's a conflict or if there is some kind of ambiguity. The very first one is, of course, the highest law of the land, the U.S. Constitution. Nothing you do can be unconstitutional. Can't break that one. From down below that, we have federal statutes, the Federal Fair Housing Act, the Bankruptcy Code, and a few other relevant statutes like that come up often and intersect with community associations. The Federal Telecommunications Act governs what you can and cannot do regarding your homeowners and where they put some of their satellite dishes and other things like that. So that goes up above anything else that we're going to see down below. Down below there, you have Maryland statutes. As Jason mentioned, there are a lot of them. They are sometimes somewhat complex. The Maryland legislature is very in tune, reactive, responsive, and at least tries to address things that homeowners associations and condos deal with in the state of Maryland. Sometimes they take big swings. Sometimes they're a little bit complex, but those laws are out there. But if they cannot go up this chain, they can't violate a federal law and they cannot violate the Constitution. There are Maryland regulations, things like zoning especially, that govern what your association can or cannot do. And those are not only for zoning, but for local municipalities, for parking, and for other things that counties may say. Down below that, we have your association declaration. So whether you're a condo or an HOA, you have a document that creates your association that addresses and references the plats and says this is the property that we're dealing with. This is how it is divided and subdivided, and this is how it is owned. All right, those things are definitely in your declaration. Nothing there can go upwards and violate any of those statutes up above, like we talked about. So, for instance, even your declaration, when you put it in there, that has a lot of force of law in the state of Maryland. It is a binding contract. However, it can't violate the Federal Fair Housing Act. As you go down, we have the bylaws. A lot of the times, those are the nuts and bolts. Those are the tools to accomplish the things that we see up above in the declaration. Tells you how to run your meetings and or how to run your elections. Might have some use restrictions in it. Might say what you can and cannot delegate from the board to your management company and other things like that. Association rules and regulations or policies. Now, declaration of bylaws are recorded with land records in the county where your association is located, and they can only be amended by a vote of your owners. There is a certain percentage that is set forth. There are numbers in both the HOA and Condo Act that it can't go up above necessarily. You can lower it that amendment threshold um, by a certain vote as well. A rule or regulation or a policy is something that the board sets out that says, all right, this is something that our documents have left to the discretion of the board. Great example is architectural guidelines. Where can we have sheds or not have sheds? Is there an approved color palette for front doors? And other things like that. Styles of fences that are going to be auto approved or auto not approved. Things that the board can say and say that this is set aside to our sound discretion in those governing documents, in the declaration, in the bylaws, and tells us, that the board then can create these. So, like we talked about, you can go down this chain, you can't go back up it. You can't make a rule as the board that violates the bylaws, the declaration, or anything all the way up to the Constitution. Yeah, and so forth up and down that chain. That's the hierarchy. The relevant statutes we deal with are the Condo Act, which is located at the Maryland Real Property Article Section 11101 and following. The Maryland HOA Act, which is located in Maryland Real Property 11B-101 and following. The Contract Lien Act, and there is a Maryland Cooperatives Act. Those are pretty uncommon. My firm does represent cooperatives in Maryland and DC as well, but we're going to hit mostly HOA and condo today. And a lot of those concepts translate. A few of them are different. So you want to know what statute governs the association that you are a member of. First of all, we're going to talk about a few of the common terms of art that these statutes utilize. A big one is the common elements. So that's in the Condominium Act, and it means the entire portion of the condominium except the units. So if you own within a condominium, you own most likely somewhere from the walls in or the studs in of your property. Everything else that's outside, whether it be a common roof, whether it be the slab, whether it be the interior hallway that leads to your unit. If you have townhome style condominiums, then some of the yards out front, those are all common elements. A limited common element means something like a balcony or a staircase or a patio or something that is appurtenant and is reserved for the exclusive use or of one or more units, but not the whole place. So as opposed to what we talked about, like that common roof or that common yard out front of everyone's unit, if you have a balcony that is reserved for use of your unit or just a few shared units, that will be a limited common element. General common elements is everything else. It's the stuff that is owned together in an undivided common interest by the unit owners. And the HOAs, by contrast, own common areas. So these aren't common elements. These are common areas, and they are typically something like your front area drive-in, where there's either a big sign, entryway, lighting. Sometimes there's a tot lot. You may have some parking areas or spaces. You may have a pool or something else that is owned. But those are common areas if it's owned by the HOA. And the ownership interest is a little bit different. So that means it's owned or leased by the homeowners association. The condominium HOA or declaration. So remember where we are. We talked about that hierarchy of documents. The very top document, the very one that creates your association, it's like the charter of your association, is called the declaration. It identifies the property, the plats, dedicates the property to the condo or HOA regime. Now, this is very important, especially for condominiums, because in Maryland, a condominium is a creature of statute. So you don't necessarily, and potentially often or not, have to be incorporated. Condominiums are a creature of statute by themselves. And so once they are dedicated to the condominium regime, they exist under the Condo Act, whether or not you are incorporated. HOAs, not so much. They need to be incorporated because they own that common area together outside of the ownership of the common owners. A few definitions that commonly come up, we kind of already talked about. Condo par value or percentage interest. Right? So in an HOA, it's almost always one lot, one vote, right? Everybody who, it doesn't matter if you have a ton of square footage, if you have a big house, if you have a larger lot or yard or driveway or anything else like that, one lot, one vote. Condominiums are not so. Because of that undivided common interest ownership that everyone has in the common elements, um, the condominium declaration will say, here is the percentage interest dedicated to each one of those units. And it is typically based in this instance on square footage. And so you will have potentially 1.4% or 0.8% of the condominium that you own, of the common elements that you own in an undivided share. That's important because if your documents provide for an election based on that pro rata, or when your assessments change, they change pro rata based on that percentage interest. It's referenced or it's referred to as par value sometimes or percentage interest. The declaration often has the common areas and it has use restrictions. So things like what is a nuisance, what can be done in with vehicles on the lots, and what architectural restrictions there might be, leasing restrictions that might be able to put in place, even if the board might be able to get more specific by a rule and regulation. The general concept or the general power to regulate leasing appears in that HOA declaration. Recordation of documents. This is important because it changes between the two types of entities we're talking about. Condo and HOA declarations and bylaws, the two chartering documents that we've talked about, the declaration and the bylaws, have to be recorded in land records for the county in which you're located in order for them to be effective and enforceable. They must be recorded there. And this includes any amendment. So once you say you go through the amendment process for your condominium to change the bylaws or what leasing restriction there might be, or you go through the amending process for your HOA to change a pet policy or something else that is in those either in that declaration or bylaws. Even that's not good enough. You go through all that process, you write that amendment, you talk with your owners, you figure out what they want to do, you get a vote, you get that 60% to come out or to submit their proxies, and they vote on that amendment. You say, hey, mission accomplished. We have done exactly what the act contemplates and democratically changed the rules that we abide by. No, you're not done. You have to take it down, or you can do it electronically and have it recorded in land records for the county in which your association is located. HOA documents, including any board resolutions, have to be recorded with the HOA depository, which is sort of a subset of land records in each county. This is not true for condos. Condos, you keep your resale package, you make sure you notify people when they move in, when they purchase, really, not moving in. You give them that resale package and provide them with not just your declaration of bylaws, but any rules and regulations that you've adopted. As a condo, you're good to go. As an HOA, if your board is passing resolutions, those architectural guidelines we talked about a few minutes ago, a parking policy, a pet leasing, any policies like that, even at the board level, they must be recorded with the HOA depository in order to be enforceable. Very, very common one that especially smaller associations sometimes miss on. I've referenced it a little bit. How do you amend your governing documents? All right. The Maryland HOA Act. This is 11B. Remember, we talked about 11-101 and its following is the Condo Act. 11B 101 and following is the HOA Act. So here, I'm going to quote from 11B 116 of the HOA Act, and it says, notwithstanding the provisions of a governing document. What does that mean? That means I don't care what your documents say. We have superseded it by statute. Go back to the very first thing we talked about. There's a hierarchy. Your documents might say something. We've trumped it. The legislature in Maryland has said, nope, we're going over your head, and this is the rule on amendments no matter what. And it says that a homeowners association may amend the governing documents by the affirmative vote of lot owners in good standing, having at least 60% of the votes in the development. So there were like 4 things we need to hit in there, right? Affirmative vote. They have to say yes to it, right? You can't assume, you can't make it an opt-out provision or anything else like that where we say we're going to assume you're good unless you say otherwise. They have to say yes to it. Lot owners, Tenants don't matter, right? Or residency, that doesn't necessarily make any difference. It's the owner, it's the person who's on title. In good standing. Typically, good standing is defined in your documents as something like not either 45 or 60 days overdue in payment of any assessment. And also without any outstanding violation. That one gets a little tricky in terms of where you are in the violation enforcement process. If you've got a lien on that property, it's probably pretty safe to assume that they are not in good standing. If you're slicing it any thinner than that, you want to talk to your attorney and figure out whether or not good standing applies here. And having at least 60% of the votes in the development. So remember, we talked about for the HOA, one lot, one vote, almost every single time. And so your declaration will have a total number of lots, and so 60% of that vote. And then the very last portion says, or by a lower percentage if required in the governing documents. We talked about this at the outset, and I said, hey, you can amend that number down. What's the rationale here? Why do we want to do this? Why has the legislature made this the rule? Well, they've discovered over time that there is a certain amount of voter apathy, of HOA voter apathy and owner apathy. Getting an amendment done at an 80% affirmative vote is very, very challenging. And they do want to make sure that associations are able to be nimble, are able to update their governing documents. If you're sitting here, there's a decent chance your documents were recorded prior to the year 2000, right? Back in the 1900s, meaning that they may have some, they may be in need of some updates. They may be in need of some changes and some new alterations and things like that. And they want you to be able to accomplish that. So you can do that if you get 60% of your owners to vote. And then you can lower, or if your declaration already has a lower percentage, that is okay. But if you've got a higher percentage required in there, by statute, they've said, nope, you don't have to go that high. We're going to help you out a little bit so that you can be nimble enough to update your documents from time to time. Condo Act. And the Condo Act specifically defines in good standing, 11104. It says in this paragraph, in good standing means not being more than 90 days in arrears in the payment of any assessment or charge. And notwithstanding the provisions of the bylaws, the Council of Unit Owners may amend by the affirmative vote of unit owners in good standing, have at least 60% of the votes in the council, or by a lower percentage if required in the bylaws. So the language there is similar. There's two distinctions to know. Number one, Condo Act defines for me and for you what in good standing means, and it makes it 90 days in arrears. So it changes it just a little bit from what your docs might say. You have to abide by that one. Second, it says by the affirmative vote of unit owners in good standing, having at least 60% of the votes in the council. That's not just 60% of the units. You have to figure out, based on what we talked about earlier, percentage interest and or par value, who is holding how much percent of the entire association voting block. So if you've got one of the larger units, say you've got stack condos and the penthouse covers the entire footprint there, and so they have a much higher percentage interest. Potentially, they have a higher vote, and so you can get to that 60% in a different fashion. It's not one lot, one vote. Those are the two important distinctions there between the HOA Act and the Condo Act. Elections and achieving quorum. If you're on here, you've probably at least gone through an election. And so you've gone through that process and had owners come out and vote on who's going to lead them, who's going to be their fiduciary, who's going to make the day-to-day decisions on their behalf as a board. The HOA Act says, if you have ever struggled, if you have ever had a challenge or a difficult time achieving quorum, perhaps your percentage is high, perhaps you have that voter apathy we talked about earlier, both the HOA Act and the Condo Act allow for a way to potentially get that election and hold that election anyways, even if you're having difficulty or even if you're having trouble, you don't have enough owners coming out. So if the HOA, first of all, we borrow from the Maryland Corporations Act, section 5-206, which is the Corporations and Associations article. And that says a second meeting may be called, at least 15 days notice given. And at the second meeting, the lot owners present in person and by proxy will constitute a quorum. Now, the one very important thing to know about this provision is elsewhere in the statute, it says the first notice has to say you intend to utilize this provision. So if you live in an association, if you're a board member who is within an association that struggles to make quorum, when you send out your first annual meeting notice, check with your manager, or if you're doing it yourself, check to make sure you've got the 5206 Maryland Corporations and Associations article language in there, because that way, if you don't make quorum the first time through, you can reconvene the meeting, have the election, and you will have a validly elected board of directors. Condo Act specifically addresses this issue because the legislature is aware it's tough sometimes, or developers possibly just by not knowing one way or the other, not thinking it all the way through. Sometimes these documents are a little older, but for one reason or another, maybe the quorum number was a little bit too high in there. 50% of owners coming to an annual meeting is sometimes a big ask, depending on how much business you really do transact. So the Condo Act says something very similar at the second meeting. If you give it at least 15 days notice, the unit owners present in person and by proxy constitute a quorum. All right. So if you had that first annual meeting, you were there, everybody was there, not everybody, a significant portion of you were there, but not enough to make quorum, you can then continue that meeting to the second to that second meeting that you notice at least 15 days out in advance. And that meeting, whoever shows up for that meeting constitutes quorum for the purpose of having election. All right. So you've established your association, you've written your bylaws. The developer wrote your bylaws, but you've done an amendment. You got it recorded with land records, no problem. If you're an HOA, you've got all your policies in place and recorded with the HOA depository. You're out there and you've had an election, and even if you had low quorum, you were able to utilize one of those statutes we just talked about and make sure your election took place, was valid, is not subject to challenge, and your new board is in place and functioning, and you get reports of a violation. Something is going on where the resolutions, the policies, the rules and regulations you've got out there are being violated. What do we do? What should we do? What can we do? Let's go find them, right? Let's go foreclose and take their house and everything else. No, absolutely not. Of course not. The very first thing I tell any client is you have to go through your dispute resolution policy or procedure. And in fact, the Maryland HOA Act and the Maryland Condo Act both have explicit ones that lay this out, and they're pretty similar. We're going to talk about some of the things that they say. And first of all, they do say, unless the documents state otherwise. So if you have a different, better provision or something else in your bylaws, in your declaration, you can utilize that. But if it's silent, if it's vague, or if it doesn't cover all of these things, go through these steps. First, you have to send a written demand to cease and desist, and it has to say the following things: the alleged violation, what they can do to abate the violation, the time period, at least not less than 15 days during which it may be abated if it's something that's continuing, or a statement that any further violation may result in the imposition of a sanction if it's something repeatable. So the continuing violation is if it's an architectural violation, right? They put in a fence that is impermissible. The repeatable one is nuisance, right? They're up late playing loud music over and over again. In either of those two instances, you have to tell them you can stop this either within 15 days or you can just not do this again, and we are done. That's what that first notice has to say. Can't jump right to fine, can't jump right to sanction, can't jump right to court and sue them. And if you call me and say, hey, Brian, this person is a pain in my neck and they've been doing it for a long time, I'm going to ask you if you've sent this notice. And unless you're holding it and you say, yep, here it is, and here's the dates I sent it to them, and it tells them they can stop with no further penalty, I'm going to say, well, then we need to start at step one. That is what you must do. Boards occasionally get frustrated by this, especially if they don't have a good procedure in place or if they don't go into it having a great understanding of what this says. But you have to paper your file. I'm here. I'm an attorney. I go to court all the time. I can tell you that judges are going to say, "Where's Exhibit A? Where's the one you told them?" They could stop, and that was the end of it. So that is the first step you need to make sure that you take. Both acts specifically say that if the repeatable one occurs within 12 months, then you can pick up and go to the next step. So it's really nice and clear and defined and says if they are doing something and they stopped, they got your notice, and they stopped for 11 months, but then they do it again. You don't have to start again. You don't have to go back to the beginning. You have taken step one. You can now move to step two. If it's been more than 12 months, you have to start over again. You have to go back to number one up there. Sometimes this is frustrating for boards also. That's where the legislature has drawn the line and said, if it's happening within the same year, within 12 months of that instance, we're good with you proceeding. If not, you got to go ahead and start again. You can send them uh, the notice of the right to request a hearing, and it has to tell them what the proposed sanction is going to be. Right? So you say, all right, you did it again. You didn't take my word for it. You didn't stop when I told you to stop, and I gave you one bite at the apple already, and you did it again, or you didn't take down the offending fence, shed, front door, whatever it is. We are going to sanction you or consider sanctioning you with the following things. What's the number one? Very most common by far. It's fines, monetary fines. Just like anything else in the legal system, we don't have a great way to fix every single thing. So where we don't have a better way to determine it one way or the other, we try to put a dollar value on it and say, here's money. Same thing in personal injury when people are injured. It'd be really great to be able to just fix them or help them or anything else like that, but instead it's monetary damages. Same thing here, monetary sanctions and fines. There is also the ability to withhold certain privileges, withhold certain voting within the association, um, check your documents very closely, and then check with your attorney, and then check with your documents again, and then check with your attorney again before you start withholding parking or any other privileges like that based on a violation. It's a very, very, very contentious issue, and there is pretty significant Maryland case law on it. So don't dive into that one head first right away if you haven't figured out how firm of footing you're standing on. And sometimes boards get very excited. They're like, "Let's do this," as if the idea hasn't already come up, and this is a brand new concept. And my response to that is, uh, it has already been addressed, and people have already come up with that idea, and it's been significantly litigated. And unless you would like to also join them in that litigation and go visit the Maryland Supreme Court and find out whether or not you have done it correctly, make sure you're on good, firm footing. Make sure you have the ability to do that. That second notice has to say that they have the ability to request a hearing. This is a little bit of a change. If you've done this course about 5 years ago or so or prior, the Condo Act actually said you have to hold the hearing no matter what. You say, here's the date, here's the hearing, here's when we're going to do it. By contrast, the HOA Act didn't used to have this provision at all. It didn't tell you what your dispute resolution policy or procedure had to be. So if there wasn't one in there, a lot of the times HOAs would either A, kind of grasp at straws at a lot of different things, or B, they would just jump right to fines or injunction or something else like that. So a lot of association attorneys have been advising HOAs to follow this Condo Act for many years anyways. A few years back, the legislature said, yep, let's just go ahead and standardize it across associations. So they can request a hearing, and that hearing should be held in executive session. So say that happens, right? You've sent out your second notice. They're violating your documents. Send that notice to the owner and say, hey, we've got this information. You did it again. You're back here in front of us, and you are able to request a hearing, and they do so. That hearing gets held in executive session. Most of your board meetings must be open. They must be open to your unit or lot owners. There must be meeting minutes about them. There must be a notice in advance, an agenda in advance that says, here are the topics we're going to cover. Once this hearing is taking place, that's an executive session. And that owner can come, bring any evidence they have to support their claim, that they are not committing a violation or that they shouldn't be sanctioned. They get to see, inspect any evidence against them, and they get to cross-examine witnesses. So a lot of folks will ask, hey, I've got this anonymous complaint or this person from our association who wants to remain anonymous and say there's a violation outstanding. Is that okay? Can we go ahead and do that? There's two answers to that. Um, the answer number one is yes, if you can prove it some other way, right? So if the shed is purple and 80 feet long, and your documents say sheds can only be black and no more than 40 feet long, you can prove that in another way. You don't need that particular complaining person to come in and testify and be cross-examined and everything else like that. That's something that can objectively be proven. Flip side, you've got an owner who says, this person, my neighbor, my upstairs neighbor, is a nuisance. They stomp all the time. Their kids are noisy. They play loud rock music that I don't like to hear. It's very late. They smoke. There's sounds and smells and everything else emanating from there. Can't do that one anonymously because there's no other way to prove it. That owner must show up and say, yes, here are the things that are happening. Here are the reasons why I would like you to find a sanctionable offense or a violation. So the answer to that question, can I do it anonymously, is like every other answer to every other lawyer that's been asked since the beginning of time. It depends. But it turns on whether or not you could objectively prove that violation in a different fashion. Hold that hearing, or if no hearing is requested and they don't go, in either case, the board should meet, vote, and then record that vote in your meeting minutes and send the owner the result of that vote. It's a notice of imposition of whatever sanction you're imposing, presumably fines. Those decisions are all appealable to the courts of Maryland, and that's why you want to go through this procedure, because not only is it mandated by statute and thus it protects you, but also it demonstrates that you have exercised your business judgment. When someone appeals it to the courts of Maryland, there are going to be two different ways that they're going to talk about it. Sorry, I hit that accidentally. Number one is if it was procedurally correct, if you've done what you were supposed to do. And then number two, was it okay? Was it allowed? Was it the right fine or sanction or anything to impose? And if you've gone through this and voted and made a decision, the business judgment rule generally protects you. And a judge should not go in and second guess you and say, you fined him $500, but really I would have said $300. They should not do that under the business judgment rule. If you've gone through all of this, if you voted, they should not intervene. Budgets. At the outset, the number one thing, if you take nothing else away from commentary on budget, budget is a board function. Owners get to be heard, they get to make comments, they get to hear about it in advance, they get to be notified about it, but they don't get to vote on it almost in any instance under either one of these two statutes. This is a board level function. Okay. HOA Act says you're going to cause it to be prepared and submitted to lot owners at least 30 days prior. Send it to everybody. Condo Act says prepared and submitted to the unit owner's annual proposed budget at least 30 days prior to its adoption, right? Send it to them, and then you will vote on it at an open meeting. When you have that open meeting, set aside time for unit owner forum or lot owner forum so that people can comment. You don't have to change anything. You don't have to alter it, but you have to hear from them. And by the way, open your ears and make sure that you are paying attention to what your owners are seeing out there on the day-to-day. Now, the ones who say, 40 years ago, we didn't used to pay any of that. We used to pay a fraction of this amount, and it was so cheap, and I don't know why we have to pay so much more. You can at least helpfully explain to them that 40 years ago, gas cost less, and insurance cost less, and the materials that we use cost less, and all of the repairs and everything else that we were doing on your behalf cost less. You could explain it to them. You don't have to convince them one way or the other. But on the flip side of that, if they say, hey, we're seeing things in the association, we would like you to spend more or less on security, more or less on tarring over the parking lot and refinishing it more frequently, more or less on, the fixes for roofs and replacements. If you've got a flat roof or a shingle roof or anything else like that, that is a common element for the condo. Hear from them. This is what this contemplates, is that they are going to get it in advance, come tell you their thoughts, and then you'll at least thoughtfully take them into account before voting. But as a board level function, should be adopted at an open meeting of the association, and you can send it to them electronically. Maryland's statutes are gradually coming into the 21st century and acknowledging what it still refers to as electronic transmission. Um, if an owner has input their email into your system or said, send me stuff via email, then you can send it to them via email until and unless it fails twice in a row. If you get 2 bounce backs in a row from that email, have to start mailing it out to them again or contact them and get an updated email submitted. Governing documents, common provisions. So some things that we see as we go through and we deal with these. Like I said, all the things we've already accomplished so far. Now, not only have we elected our board, but we've set out our budget for the year, and we've adopted it. Our owners know what we're targeting to spend. By the way, that budget, that's a target, right? It is not a ceiling. It is not a limitation. It is a target. It is what you are trying to accomplish. And if you, at the end of the year, say, hey, we're over or under budget, the best thing you can do is adjust for that the ensuing year, because from that budget, where is going to emanate your assessments, right? You're going to say, all right, to run the whole place for the whole year, we estimate it's going to cost, I'm an attorney, so I'll do round numbers. It's going to cost $100,000. And we have 100 unit owners. So everybody needs to pay 1,000, right? Over the course of a year. Great. No problem. And we can break it up over 12 months. Piece of cake. Turns out it cost you a little more, and there wasn't anything particularly outstanding. We're not talking about reserves. We're not talking about a catastrophic loss or a big insurance issue that fell through or anything else. It just turns out it cost a little more. Prices went up. Your water bill was higher. The maintenance, the snow removal contract, whatever else it is, was a little more. Go in line by line and at least figure out where you missed big and adjust it for the following year. Because that way, if you're over budget year over year over year, first of all, your owners are going to complain because you're going to be taking their money and not doing enough with it. They're not going to get commensurate services. If you're under budget, well, I did that in inversely. If you're under budget year over year, that's what'll happen. If you're over budget year over year, they're going to complain because they won't get all of those services. You won't be able to pay for those things, and you're going to have to crank up the assessments a lot more in future years, or even impose a special assessment, which people don't love. Common provisions of your governing documents. Rules for the conduct of meetings. This is a big one. Have an agenda. Anytime you're going to have a meeting, annual meeting, board meeting, even committees, have an agenda. Send it to your owners in advance. Tell them what you're going to do, what's going to be talked about at this meeting, so that they know, can participate, can hear about it, can decide if they want to be heard. And in the future, if they say, you didn't tell us you were going to change the parking policy, you can say, oh yeah, actually, here's the agenda that we sent you in advance of that meeting, which very clearly told you that was the day we were going to talk about it. So you should have come out. The order of business, quorum requirements. We've talked about that and how those sometimes are a hamstring, but make sure you know them. And vote requirements for the passage of different types of business items, right? The annual meeting, what you need to do the election, the budget, and whose responsibility that is, if you're voting on an amendment, if you're voting on a board rule, regulation, or policy. And often they will provide for, or even if they don't, a lot of attorneys usually suggest, if you've got difficult owners, if you have a hard time staying on track, if your agenda gets too unwieldy or anything else, utilize Robert's Rules of Orders to keep things moving in the right direction and to make sure everybody at least gets the opportunity to be heard. All right, so in your documents, it will define the board of directors. It'll tell you some things. Number one, it'll tell you the number of them. I very recently came across my second set of documents ever that had an even number of board members. run like hell in the other direction if this is true. Get down to the land records and amend that out of there. You want to have an odd number of of directors on your board at all times because sometimes you're just going to have to vote, and people aren't always going to see the same way. Try to govern via consensus. Try to reach an agreement. Lots of your stuff will be unanimous, no problem, piece of cake. But if you've got a number of board of directors that is even, you are walking towards a problem. It'll tell you how you are eligible for the board. Um, the most common provision is to be an owner, but that is not necessarily true. So make sure you're familiar with your documents to figure out if you have to be an owner, if you have to be a resident, if you have to be current on your assessments, if there are any other eligibility requirements or not, or those eligibility requirements do not exist in your documents. Be familiar. Length and stagger of terms of office. A lot of the times, these can get lost over the course of time. You've got the same 3 or 5 board members who have been coming out for a few years, and they've been elected by acclamation. Everybody's generally cool with what they're doing, and they come year after year, and we kind of just all give them the thumbs up and move forward. If you ever lose that stagger, and the stagger is really, really important to preserve what I refer to as institutional memory. You don't want to have all 3 or all 5 of your board members depart in the same year. That can be really bad because people won't know where you keep things, how we've done it in the past. Look, this is how we've always done it is really, really bad logic by itself. However, you need to know how you've always done it. A lot of the times the association is bound by precedent, by actions that it has taken in the past. Your owners will know and they will be familiar and they will say, hey, like we've really always done it this way. And nobody's ever given us a hard time before. So you want to know. So for all of those reasons, if you've got a 5-member board and it says everybody's on 2-year terms, but there's 3 up for election this year and 2 up for election next year, and they're cycling, right? They're always staggered, they're always cycling. Be aware of that. And if at any time you lose that, go back and have another annual meeting where the top 3 vote getters get a 2-year term and the lower 2 vote getters get a 1-year term, and then have those folks from this year who get the 1-year term be elected again next year to the 2-year term, and your stagger's right back in place. Methods of election removal and replacement. Usually the board is voted on by the owners. Typically, you can only be removed from the board by the owners as well. And replacement, if someone steps down, is removed, moves out, anything else like that. Ordinarily, what happens is the remaining board members place somebody into that vacancy until the next election takes place and the owners can vote again. Notice for and number of board meetings. A great tip for this is you're supposed to notify your owners of all your board meetings in advance. You can comply with this at the outset of the year by saying the first Tuesday of every month at the clubhouse at 7. And if you tell them that, boom, you've complied, right? Even if you don't get around to sending it out in advance, that first Tuesday creeps up on you sometimes. But if you've told them this is where we'll be every single month and you've let them know already, then you can have that meeting and transact any business you could otherwise do, even if you didn't get a notice of that particular meeting sent out 10 days in advance. And the powers and duties of the board are always in those governing documents, so look at those very closely. Officers, all right, if you learn one thing tonight, it's budget is a board duty. If you learn 2 things, officers and directors are almost never the same thing, right? The board is 3, 5, or 7 members who votes on big, high-level issues for the association and is a group of fiduciaries. Look at your governing documents closely because I'm willing to bet in 98% of cases that if you say, I was elected by the owners as the president, that probably is not the case. Your unit owners or lot owners elect your board. The board then selects the officers. And the officers will have roles, powers, and duties. Most common are president, vice president, secretary, treasurer. And a lot of the times, we talked about how they are elected and removed and replaced, eligibility. And the eligibility one is a really important one because a lot of the times, we talked about earlier, the board often has to be unit owners or lot owners. Not so necessarily with the officers, especially secretary or treasurer. If you have somebody, I always call on my colleagues who are retired CPAs, retired attorneys, even who have a certain very specific skill set, whether it be taking and keeping and recording meeting minutes, or whether it be helping with the transactions that go into the budget, the not setting the budget necessarily, but tracking the transactions, especially for smaller associations. This is a great gig that they can handle without having to do all the board meetings and all the board functions and everything else like that. You can have them be secretary or treasurer, and move forward in that fashion. I went through those kind of quickly because I wanted to hit the portion about eligibility. But it's important to know the difference between the board or the officers and sorry, the board or the directors and the officers, who are the vice president, president, vice president, secretary, and treasurer, and execute some of those functions. All right, so your governing documents are going to tell you the maintenance, repair, and replacement for the common element and the units. Make sure that you know how they are identified. The unit and the common elements, that's going to show up in your declaration typically, and it'll say, here's the boundary of the units, and it's either the interior wall, or it studs in, or whatever else it is. Know who repairs what and who replaces what. Recovering the deductible, which is 11,114. In Maryland, um, your condo master insurance policy is supposed to bring the units and the common elements back to the way they were prior to the instance, or actually at developer turnover. We call it builder grade sometimes. So there's an insurable event. There's a water leak, the most common one. There's a pipe leak. Your master condo insurance policy is going to come in and put all the units in, all the affected units and all the affected common elements back to the way they were at builder grade or at turnover, right? You will have a deductible of some sort. Um, if it is $10,000 or less, you can pass that through to the source unit owner. That is where the incident originated, and it's pure geography. If it's within the bounds of the unit, it goes to the source unit owner. If it's within the common elements, can't pass it through. It's a common expense. It's paid by the condo. The number here is 10,000 for Maryland, or less if your deductible is less. If your deductible is more, you cannot pass that deductible through to the source unit owner. Oh, sorry, you can't pass more than the 10,000 through to the source unit owner. Maryland, some common bylaws provisions. So we talked about in the HOA, typically you're going to see a lot of those use restrictions show up in the declaration, which you can and can't do. The condo bylaws almost always are going to have the use restrictions. They're going to have things like pets, leasing, parking if there is some. What is a nuisance? Smoking if smoking is addressed, and various others of those use restrictions. Nuisance, and is it defined? My favorite sentence to say is nuisance is inherently subjective, right? Everyone wants to say, this person is a nuisance, or my upstairs neighbor is a nuisance. I even referenced it earlier in this discussion, and I said, that this is something that the association may have the ability to enforce. If it's defined, great. If not, well, in either case, you want to go through your dispute resolution policy, but you want to have a vote. You want to hear the evidence. You want to determine as a board via a vote if this conduct rises to the level of nuisance. Pets, we talked about where you have to reside. Is there a provision on no impact home-based businesses? If they're not seeing clients, if they're not increasing traffic or anything else to your association, if they're not otherwise impacting the association, then you want to look at your documents because they are specific and they will say either yes or no. And in Maryland, there's a lower amendment threshold. So if this is, sorry, because once again, the legislature has decided this is a decision they want each individual community to be able to make. Are we okay with this? Are we not okay with this? So there's a lower change threshold, there's a lower amendment threshold to either add or prohibit no impact home-based businesses. So you want to be very familiar with what your documents say on this and whether or not you can enforce. Talked about leasing and any exterior usage requirements or restrictions. Leasing, we could do 2 nights on and discuss all the various topics. A big one, especially a few years back, is Airbnbs. Um, Typically, condo and HOA documents will have a provision that says something like no hotel, transient, short-term use. If the word short-term is in there, usually you're in pretty good shape. A lot of the times, if you have a minimum initial lease term, that's fantastic because if they have to rent it for a minimum of 6 months or a year to start, then that prohibits those Airbnbs. And if your association is looking to do that, they have something right there to hang their hat on. You're also going to have your architectural review committee, what happens and what your rights are if a property falls into disrepair, whether it be a lot and they're not cutting the grass and the shingles are falling off and what have you, or whether it be a unit and you've got potentially a hoarder situation or you've got pests and other things emanating out of it. Know what those documents say. You comply with zoning. There's always a provision in there that says there's no illegal or immoral purpose. Don't rely on this. You don't want to exercise and try to have your judgment in there as to what is immoral, and then be up in front of a Maryland judge telling them that you made this decision one way or the other. You are simply inviting litigation there. Find something more objective. Talked about the ways that you enforce, and we looked at the both the acts, the HOA Act and the Condo Act, which say your documents can say something different, unless they are just as specific and just as step by step, point by point, and unless they give that owner one first shot to comply and to stop without any further penalty. You want to go ahead and comply and follow that policy as well. Notice and how notice gets sent out, what notice is required in advance of a budget meeting. Sometimes your documents are uh, require a greater period of time that budget has to go out in advance. Sometimes if you're going to pass a special assessment, it's important to know how to notify owners that is under contemplation and whether or not it's going to take place and when and where you're going to vote on it. Opportunity to be heard about the enforcement, what the sanction is, fines and fining schedule. This is a big one. If you're going to put out these policies and these dispute resolution policies, the best thing you can do is do it during peacetime or do it before the violation shows up. Not when you are dealing with someone already and they're already in front of you, because that will come off. It will look retributive. It will look specifically targeted. And what you want to do is have a rule that applies to everyone broadly. Pass a fining schedule when you're not dealing with any violations and say, here are the things that we will fine for, here are the amounts that we will fine, here's how frequently we will do it, and have that policy in place. Judges will look for that. They will ask to see it. So if your question or if your enforcement procedure ever does get appealed to the courts of Maryland, like we referenced earlier, you want to be able to say, yep, we relied on this document right here, and the owners all have it, and they get it, and it's recorded with the HOA depository in the county where we reside. Most documents, if not, well, a humongous percentage, 99.9% of documents say that you can recover attorney's fees and costs. This could be a long discussion. Also, some things to keep in mind though are number one, look at what your document actually says as to whether it says prevailing party, as to whether it says the substantially prevailing party. This is whether it says the association can recover its legal fees and costs when bringing an action to extinguish a violation, or whether it says something slightly different from that, and make sure that you aren't putting yourself on the hook potentially for a judgment for legal fees in the other direction if for any reason your enforcement is not successful. Be aware of that. Also be aware that this is a contract provision. It's not a magic genie who goes and takes that person's money and puts it into your pocket. You have to go through the process. You have to get a judgment. Sometimes you have to enforce or collect on that judgment, garnishments, levies, other things like that. If someone is already not paying you and these amounts start getting higher, you might be hard to collect against them for that entire full amount. So don't treat that as an absolute no-brainer backstop. Make an informed decision as to whether or not that's something that you can count on or expect, and make a good financial decision for your enforcement procedure based on that information. And we talked about it's appealable. An injunction is the, well, let me rephrase that. The way that we talked about enforcing and the top way is fines. Talked about how to do that. We talked about how to motivate people. We talked about how to pass a fining schedule. The other thing available to you is an injunction, which is a court order requiring someone to do or stop doing something. It is enforceable often by the sheriff in the county, and that is something that you can request in most cases only from the circuit court. I point that out to say that circuit court cases are generally longer, more complex, and thus potentially more expensive. So you want to keep that in mind when you call your attorney and say, hey, let's get an injunction to stop this person from doing X. They're running a dangerous, auto body replacement shop right out on their front driveway. Yeah, absolutely, you want to do that. If it's something a little bit lower, you want to at least start with something quicker, simpler, cleaner, like a monetary fine to see if you can motivate compliance. So, we're going to talk just a little bit about the new Maryland rules that have come into place recently. They were passed jointly as Maryland Senate Bill 758 and House Bill 1534. And these rules did become effective legislation as of October 1 of this year. So these are now correct, true, and accurate representations of what the law is presently. And the biggest one that you may have heard about, you may have read about, you may have been told by your management company, your attorney, or just your neighbor or owners, is the independent parties requirement. Maryland associations must now have their elections conducted by independent parties who are not candidates in the election and do not have a conflict of interest regarding any candidate taking part in the election. Now, for many, many years, associations have at least been trying to accomplish this, right? You select your inspectors of election in advance, a couple of people who are there, who are owners, who don't have a dog in the fight, one way or the other, who haven't been campaigning for one of the particular candidates to the board or anything else like that, and can be objective, right? This is going to pass muster, and this is what you want to have happen. The legislature has codified this and said you have to now accomplish this in order to have a proper election in the state of Maryland. And community association managers of many associations will not qualify as independent parties. Any of the professional management companies that I know or cannot do this on their own. Most of them have been declining to do so anyways because they don't want to be called as witnesses. They want to make sure that the association is doing its own business, that they are there to be support and facilitate only. This is one of the basic things that people are being told is that probably your management company can't just run your whole election. You're going to have to appoint your own independent inspectors. Okay. Independent parties, and it's defined right here in the act. And it says includes qualifying unit or lot owners, property management owned by the association. All right. So if you've got an employee that is paid directly and that's what you do, that's how you run it, then it's potentially different. And third-party vendors or commercial technology platforms. So there are vendors out there. Your colleagues here at Majerle Management probably have a list of them who they can tell you, hey, these are some that you can look into. I suspect, will not recommend or advocate for any one specific. They will give you a list and say, hey, you need to go get your own contract and contract with this company to run this election or to be your independent inspector. And there are a number of them out there. They've been there for a while, and now that this is legally required by legislation at the state level, there's going to be probably a bit more of a need for it, at least at the outset. If you're running your election and you've been doing it for years and you've already chosen your every year you choose your two or three independent inspectors of election, and they go into the back room and they double count the votes and they make sure that everybody's coming out with the same number, and then they announce the results. Great, this doesn't affect you at all. You can keep going through that exact same procedure. If you have not done that, you may want to consider one of these third-party companies, or you may want to, prepare in advance and or have someone or or a couple of owners who you know are going to be willing and able to volunteer who are not running, can't be candidates. Unit owners and lot owners, and this is right here from the act as well. So it's important to know the specific language that they've utilized in this legislation. It says unit owners and lot owners can qualify as independent parties as long as they comply with the remaining requirements of the Condo or HOA Act. So first of all, they have to be eligible voters. They have to be supposed to be at this meeting in the first place. You can't just bring in a couple of people off the streets necessarily. They cannot campaign or electioneer for any of the candidates, and they're not subject to the objection of more than 25% of the unit or lot owners who are eligible to vote. So there's a objection procedure right there in the act. This is a new one, like it just became law 28 days ago. I haven't seen it play out enough times to talk about it statistically or anything else. But I will be interested to see, you will probably be interested to see too as well, if there are going to be significant ones that fit this very last criterion, which is people have objected. 25% of the eligible lot owners have objected to a person being an independent inspector or an independent party for the purpose of inspecting the election. Um, if you made me guess, if you made me speculate, I'd say I don't think that's going to come up all that frequently. That takes an awful lot of boots on the ground work to have someone really objecting to your inspectors. If you've been doing it the way that is contemplated by the act already, you're probably going to be in good shape. The other thing that the act recently put in place is the limitation on charges for books and records. So you most likely know that as a condo or an HOA in Maryland, you are required to keep your books and records, right? Most of those are your meeting minutes, your budget, your documents, including your governing documents and any rules, regulations, policies, and anything else that you are doing that is not otherwise subject to being privileged or withheld from your owners. Everything else, the presumption is that owners get to see it. And I mentioned this earlier, but the Maryland Acts were written in a time where we loved paper a lot more. And everybody had everything on paper. And these were filing cabinets full of things, and binders full of things and everything else. And so you had to have them available for inspection by owners. And if the owners came in and wanted to make copies, you could charge them whatever the library charges, 10 cents a page or 50 cents a page, whatever it is now. You could charge for the reasonable costs, and that was it. As things have become digital, there's sort of an open question as to what that means for what charges or you can or cannot impose on owners who are requesting those documents. And this solves that question or resolves that question. And it says a couple of things. Number one, you cannot impose charges for examining the financial statements or the meeting minutes of the association in person. So if they just want to come and show up and it's during regular business hours, can't charge them anything. Can't say, oh, well, I have to have a manager there to supervise you and I have to pay them, and thus you're going to have to pay my charge. And this is, I think, well thought because you don't want to disincentivize or put up boundaries or barriers in front of owners who just want to see the documents they're already entitled to see. So if you've still got that big filing cabinet, owners get to come and see it during regular business hours at no charge. And if you just email them a PDF and it didn't cost you anything, you can't charge for that either, right? So anything digital or anything electronic, you cannot charge for. And if they come during regular business hours, you cannot charge them for it either. You can if those two criteria, if either of those two criteria is not met. If they're saying that they want paper copies and or if they want to come and look at them after regular business hours, then you can charge the reasonable costs that come up. Those are the two big changes to the law that occurred most recently and that went into effect on October 1st. Number one, the inspectors of election or the independent party inspectors of election. And number two is the limitations on what you can and cannot charge for copies and for inspection of records. Those are my comments. We covered a lot of stuff. Hopefully some of it was review. Hopefully some of it was new and helpful and relevant and guidance. And I think my colleague Jason maybe has aggregated a few questions that I can hit.
I did. First and foremost, Brian, thank you very much. Appreciate you spending some time with us this evening. We got a good number of questions that were submitted. We're going to take this till roughly 8:30 in terms of just general questions. And I do apologize if I'm not able to get to all the questions that are in the chat. We're going to start there first for those homeowners who came in. I would say this: the top question that I got, Brian, is people are loving this slide presentation and may want to know where they could get a copy of it. Could you give us a little bit of color on that, my friend, in terms of if they wanted some of these details? I will remind the audience we're going to have sessions that we do, such as this, and future sessions posted to Majerle's website under resources. But Brian, the people are wanting to know where they can get this information from, my friend. Could you give us a little bit on that?
The slides themselves, I don't mind sending out. So I don't know if you had a distribution list or if you'll have a post distribution list, Jason, or I mean, if you want to aggregate a post email list, I don't mind distributing the slides.
Okay,
Those are just
wonderful.
things that I've pulled together, over the course of my time. So.
Wonderful. I'm going to try to pull that information so we can get that out. But for homeowners, excuse me, board members, for a little sneak peek, Major League's also not only working on a new logo, but working on a new website. And like I said, sessions like these, we're looking to post evergreen to our resource library so you can view these type of educational sessions in the future. We got a lot of really good questions on there. I do want to pick one or two that I think would be pertinent to the group, but I'll try to at least start with the earlier questions that we have. And one of our audience members asked, we have some confusion on our board about the relationship between our bylaws and Robert's Rules of Orders, which our bylaws reference and require. Can you elaborate on how that works?
Yeah, that's a great one. And it kind of goes back to, at the very first slide and the hierarchy of documents. So the bylaws can say, hey, you are required to use or you have to use Robert's Rules of Order. If the bylaws also prescribe things like the agenda, the things that you have to cover, and notice that owners have to receive in advance, those are very, very important. There's also or often a lot of confusion about what Robert's rules apply to and when they are utilized. So if you are having a board meeting, then the president can utilize Robert's rules to go through and make sure that motions are being made, seconded, discussed, and then if discussion has reached an end, to make sure that we're moving on, and then call for a vote. And if the motion doesn't pass, to go on forward. You're not supposed to be able to get filibustered out of a board meeting. And similarly, at an annual meeting, um, owners do get the opportunity to be heard. There are things that the entire council of unit owners or the lot owners for an association do get to vote on, but they do need to be on that meeting notice in advance or the agenda in advance. And once again, one owner at an annual meeting cannot necessarily utilize that process to just hijack and go down a specific road that the meeting wasn't called for. So. There are a number of good parliamentarian sites out there to determine, Robert's Rules of Orders are supposed to be a tool. They're not supposed to be a weapon utilized by one or a small group to hijack that meeting. And when those two things conflict, even if your bylaws say use Robert's rules, if there's a conflict between the two, the bylaws still go over the top.
Appreciate that. Darian writes, longtime listener, first time caller. Appreciate that. Thank you. Shout out to one of our members here. I want to ask about quorum for an annual meeting for voting. Can this be established by a submission of electronic votes? And Brian, I think the answer for that is yes. I've seen, at least from our vantage point, with a lot of the new online voting systems that we have, there is a section now that allows for tabulating quorum just for the purposes of quorum or designating a proxy as well as the vote itself. Any color on that, Brian?
Yeah, I think there's a couple of questions there. And the answer, I'm kind of nodding along because the answer is yes to all of those things. Number one is, can you establish quorum via someone who's attending electronically? The answer is yes. You have to be able to confirm unit ownership in some fashion. You have to be able to track those things and make sure that they are at least who they purport to be, and or they have the information relevant. You can also request owners submit a proxy just for the purpose of quorum. So sometimes we run into the situation where say, look, we haven't had owners to come out and vote, and we just really want to transact our annual meeting business and make sure that it is above board, that it's not going to be challenged, that we are the fiduciaries so that we can accomplish all the things we need to do. We can fix your roof. We can make sure the parking lot is repaired the way it needs to be. And so if an owner says, look, I don't care, I don't know any of these people, and I don't want to vote one way or the other, they can still submit a proxy that just says, yep, count me present for the purpose of quorum so that you all can accomplish an election. And I've got a valid board who's paying the bills and making sure that there's insurance in place on the units and everything else.
Appreciate that, Brian. Another great question that we got, which is how do we determine that the declarations filed with the county meet the lawful standard to be valid?
Well, if your association, whether it be an HOA or a condo, has been established by the developer and there's a declaration that was recorded, that probably that almost certainly creates your association. You can ask an attorney for their opinion as to whether or not it's okay and it was valid. But some things to look for are, first of all, if you're incorporated, make sure that you are also in good standing with the SDAT, with the Maryland State Department of Assessment and Taxation. You have to file that annual personal property report and do it timely, or you can fall out of compliance there. And going on down the list, your association documents, if they are recorded with the land records for the county in which your association is located, you can find all those online at marylandlandrec.net. You can look for all those. You can sign up for a free account. You can search for those things and make sure that they are there, that they have properly attached to the lots that they are supposed to. You can dig for the plats as well. And if you want to consult with an attorney to do that, or if you just want to go digging and make sure that those things are all where they belong. The HOA depository is typically not online. You do usually have to go to the circuit court courthouse and locate that, and then speak with the clerk. And like I said, sometimes they'll charge you the whatever it is now, 10 cents a page, 50 cents a page for the copies of things there. So you can confirm that as well.
Appreciate that. Really like this question because I think it's one that we get a lot in terms of the budget process, which some of our clients and other audience members are attending right now. And it's a little bit of a procedural clarification, which is asking regarding voting on the budget, is there a requirement to vote on the draft budget, let's say in a more formal sense, to release that to the homeowners as the proposed?
You want to check your governing documents to see if there is an explicit one. If not, then the board really, when they're sending that proposed budget, the act only requires that you send the proposed budget at least 30 to both acts, at least 30 days in advance of the meeting where you're going to vote on it, and then vote on it at an open meeting. It doesn't have to be a two-step process. Your documents may say otherwise. Your board may have done it that way in years past, establishing a certain expectation from your owners that they see a draft budget and get a comment on it. Quite frankly, especially for larger budgets or where you have a lot of unitors or a lot of owners who are paying attention and have comments on it, it's a best practice. It's a good idea to put out a draft budget and say, hey, here's what we're considering, but we're not voting on it yet. We'd like to get your input now. Because if you go the way of the act, technically you're going to hear from them and then decide whether or not you want to wait and make any of the changes they've suggested, either right there in real time, which is very hard to
Mhm.
do, or push it and have a second meeting. A draft budget is a great idea. The act does not require it, and that doesn't mean that I'm saying you shouldn't do it. But you unless your governing documents have a specific provision of that, or like I said, If you've established an expectation among your owners, you generally want to keep that up. They'll say, hey, every year up until now, I've seen a draft budget and I came to expect it. Go ahead and follow that policy or that standard way of doing things.
Appreciate that. Got another one here, and I'm going to try to jump at least to everybody's initial first question and then some of the follow-ups. Another one here from Suzanne, who writes, when we see the word shall in the Maryland statute, the Maryland Condo Act, declarations of bylaws, CC&R, please confirm the obligation of the board and management to follow. And we see a lot of times may, we see a lot of times perhaps or will, but when they really lean into the shall portion of that, Brian, can you talk about that particular line?
Yeah, 100%. If this shall, it is a requirement. That is, contract drafting, statutory interpretation. If it says shall, it means you shall do it. It means you must do it.
Excellent. I think this is a big one and something that is certainly lingering with a lot of people. We got one from Jacqueline, who writes, Jason, can Brian address the law regarding the reserve study requirements for both 5-year update and the actual completing of items identified in the study? Can the board decide we don't want to replace XYZ or budget for those items? So I know we got a lot of the mandatory funding that's been coming down, and homeowner boards are dealing with that. Can you talk a little bit about that for us, Brian?
Yeah, absolutely. I mean, I could talk a lot about it, but and have on different occasions. But I'll try to stay on topic and narrow it down to at least the nuts and bolts. The short version is you got to have those studies and you got to be funding them. Whether or not you are actually uh, making those replacements is a little bit less clear and explicit, but there's, A follows B. So if you're doing the study says fund it, and you're funding it, and then you're just not using that money for those purposes, and it's just sitting right there in your coffers, you're probably breaching your fiduciary duty, even if it's not necessarily something that wasn't, or sorry, that was a shall do it under the statute or anything else. So you are required to have the reserve study. You are required to be funding it on the schedule that is set forth. And then you are required to use those funds for really only that purpose. I'm aware, I live in the real world, that there are associations that occasionally borrow from reserves. To the extent that that ever takes place, I would say, first of all, try not to. And second of all, document, and then repay it on a time schedule that you have already set forth and documented and plan to do. But in terms of the reserve study itself, um, have it every 5 years, and then be funding it in that fashion.
Appreciate that. Got another great question here. Can you break down the statutory timeline for the annual meeting for a condominium in terms of when a call for board nominations needs to come out? Needs to come out to notice of election, to the draft budgets, etc. So I think that audience members asked for a little bit in terms of where we see the timelines noted in the governing documents, but some of the Maryland Condo Act and Maryland HOA Act in terms of how that folds into scheduling out the election from call for candidates all the way to counting the votes now.
You typically hear the statute is a little deferential, and in Maryland, a lot of the times it's not. We talked about the amendment provision, among others, and the dispute resolution procedure, which is nominally deferential, but which you want to follow, and the deductible provision, which is, sorry, the insurance deductible provision, which is not deferential at all. Here, the statute generally will allow for what your governing documents say. So if you're going to do a call for elections, and if that timeline is set forth in your declaration or your bylaws, that is what you want to follow. You do want to do a call for candidates. You do want to notify your owners and all the attendees of the annual meeting whether or not you are going to allow for a call for candidates from the floor. While that's not a statutory requirement to have it, if you're going to do it, you have to, sorry, if you say you're going to do it, you then have to have that ability. That has gotten a little bit trickier and more complicated as in the age of Zoom, to call for candidates from the floor. It is and was easier when everyone is in the same room as opposed to doing it online, but it is still viable. And so call for candidates in advance. and then put out that annual meeting notice. Make sure that your annual meeting notice lists the candidates alphabetically with no order of preference and with no distinguishing or list saying that they are that they may be um, already sitting board members, that they may be incumbents, is the word I was reaching for there.
Got an instant follow-up on that one. I think this kind of talks to a broader question that comes up. Brian, when you have the governing documents being silent on a particular item, or let's say the Maryland statutes are silent on a particular aspect, how do boards navigate that besides talking with attorneys like yourself?
Uh, that's the best answer is to go, is to consult with a professional, find out somebody who has gone through this process before. A lot of the times your seasoned association managers have at least, can point you in the right direction or say, hey, common practice is this or that. Anytime you're getting into something where you're either going to impose a charge or you're going to impose a sanction, uh, check with not only your community association manager, but in that case, your attorney. Similarly, if there's an insurance question, even if the documents or the act is silent on what you think is going on, check with your insurance carrier, your broker, or your professional there. Same thing for reserves. I talk a lot about reserves. There have been classes upon classes about what the statute means for reserves. At the end of the day, if you say, hey, well, I got this very specific question, get a very specific answer from a reserve study professional. The community association industry is broad, and the bench is deep in terms of people who are doing this work and who have seen it before, and can probably at least steer you in the right direction or provide you with best practices.
Appreciate that. Do two more questions and then we'll round out our Q&A. I think this is a pretty good one for our Prince George's County-based HOAs in the House tonight. Looks like county government, county council specifically, is moving some new legislation. I just appreciate that owner providing me that link, DJ, where we have County Resolution 085-2025. And for those in our audience maybe not familiar with that, apparently that is a resolution concerning common ownership communities program rules and regulations proclamated for the purpose of the county council proclamation of rules and regulations governing the implementation and administration of the common ownership communities program. Brian, our audience member was asking, do you have any background in terms of some of this legislation that's coming in? It looks like on the website we see a favorable recommendation with amendments out of Planning, Housing, and Economic Development Committee just a couple of days ago. Any familiarity with that particular one? That's a new one on me actually, and I think there might be a question of contradiction of existing state law. Maybe the county's taking a little bit more of their own stance when it comes to how they're administering rules and regulating HOAs. Love any item on that, or we may need to pass on that if you don't have the background, because that's a new one on me.
We're still kind of digesting all of these things. I think a broader statement for me to make is the Montgomery County CCOC, or Commission on Common Ownership Communities, has existed for quite some time. And if you're based in Montgomery County, then you're at least nominally familiar. There are a few things that that county requires in terms of board training and then what you have to do in order to go through a dispute resolution procedure there. Other counties have tried to expand or have looked to base off of that model, or just generally try to be involved and give some county specific guidelines where they know their constituents are dealing with community association issues one way or the other. The devil's going to be in the details in terms of how all of that kind of sorts itself out. And so I will say right now you want to consult with your community association attorney, or I would say wait and see what this is going to mean for you specifically. But those are still kind of working themselves out.
I would also add we have for our own DC and Chesapeake chapters of the Community Association Institute, the legislative action committees. If you check out CAI DC, CAI Chesapeake, you'll find links from the main chapter to those legislative action committees. There are groups of homeowners, professionals like Brian, for example, management companies, practicing community managers who are out there monitoring legislation from not only the federal level, the state level, but also the county level. So they got eyes and ears. Last question I want to ask Brian to kind of wrap things up is a little bit of a selfish question from management. Some boards will often say, well, Jason, we've adopted a particular procedure or we adopted a particular policy in a meeting minutes. It's something we've always done. And there may be some hesitancy to adopt a formal resolution for what may seem like no brainers, baseline operations, things that we always know it's been $25 for the fob. Can you talk about resolutions a little bit more, Brian, in terms of memorializing not only these instructions, but the processes and why those are important?
Yeah, absolutely. I touched on it when we were talking about a schedule of fines, but that's a broader, my comments go broader than that. On that topic, go broader. So if you've got something that you typically do, your standard operating procedure, and it's board level and it's delegated to the board in either the declaration or the bylaws, you want to go ahead and codify that where possible. And one of the best reasons for this is if you ever have owner challenging it, whether it be guidelines or architectural guidelines, or whether it be something else, the board, I already said, you're protected to a certain extent by the business judgment rule. But even better than that is to say, we didn't have any judgment anyways. Our documents require us to do this. We're following the rules right there, just like we do for everybody else. What I refer to as curse words in our industry is what's called selective enforcement, where you treat the same violation or the same action or the same request differently depending on who shows up. Depending, one person asks for their key fob and it's $20, and one person asks for the key fob and it's $60. There's no great reason why one way or the other. That's where you end up with problems. Whereas if you say our policy says X, we always do X. It's written right there. Here's 30 other people who dealt with the same thing. Our hands are tied. We had to do this. Not only does that win in front of a judge, that you don't even have to go to a judge. You're going to win it on that on a motion to dismiss or motion for summary judgment. As your attorney, when I'm talking about these things and these policies, I'm thinking about that. I'm thinking about that case all the way down the line where we're going to have an owner challenge it. How quickly can we resolve this? Because I say this all the time. Anybody can walk down to the courthouse and pay their 48 bucks in district court or $125 in circuit court and file a lawsuit. As much as I would like to reduce that risk, that's part of my job is to say, hey, we're going to keep you from getting sued. That is not my promise. I am not pledging to you that you will never be sued because anybody can do that for any reason. What I want to do is minimize the effect that that's going to have and increase the likelihood that not only you're going to win, but the speed at which you will win. So if you've got uniform policies and procedures, you're doing the same thing over and over again, and you can point to a document that says, we're not out here, picking and choosing who we want to go after. The documents say X, we always do X, and that is what happened here. You're in really good shape.
Brian, I lied. I had one last question. Let's say that some of our audience members say, man, I really like that Brian Fellner guy, and I want to learn a little bit more about Fellner Legal Services. Could you tell the people, maybe say it louder for those in the back, on where they can learn more about Fellner Legal Services?
Sure, our law firm's website is www.flslawyer.com. And that's where you can find our information, our contact information. We do post blog posts about cases of interest, legislation of interest, other things like that. We're also online on LinkedIn and Facebook and Twitter if you are looking for us there, or X, I guess we call it these days. But so you can track us down in any number of those digital ways, even if Maryland legislation hasn't totally figured out that that's where we all live now is online.
Well, Brian, thank you so much, ladies and gentlemen. I want to give Brian another big hand. I appreciate it. And I would also say appreciate all of you coming out. At one point, we almost hit over 50 participants on tonight's call, which is a lot of meaning for me, as this is my first formal board training session for some of our existing clients, and I'm very touched by all of you making some time to join us this evening. I'll go ahead and close things out. For all of us here in our Rockville studios, we appreciate you coming out for tonight's session. Keep a lookout for new future sessions. We got a lot more. We got a lot more coming your way. Thank you, everybody. Go get something good for dinner if you haven't already. We'll see you the next time. Thanks, everyone.
Thank you, everybody. Thank you, Jason.